We just need to wait a couple of seconds until we'll have a full room. Okay, I guess I see 230 people, so I guess we can start.
Okay.
Annette, would you like to?
Yeah. Okay, good morning, everyone. Welcome to our talk for Privacy Week. We are looking at privacy in the wake of large language models. With all the developments and all the talk around ChatGPT and other developments, we thought this was a really good topic to bring to the forum this week. So my name is Annette Mills. I'm a professor in information systems with the University of Canterbury. And my co-presenter, I'll let him introduce himself.
My name is Marcin Betkier. I'm chairperson of the Privacy Foundation New Zealand and a lecturer at the School of Law of Victoria University of Wellington.
Thank you, Marcin. And I'm also with the Privacy Foundation. So, there's the flag. So, of course, organizations are all thinking about artificial intelligence. It's a big, powerful asset for organizations, but it needs a lot of data. And this results in certain threats to data privacy, security, and of course, issues around regulation. How do we deal with these developments? So one of the key tenets of this presentation is to look at how can we use or innovate with large language models, of which ChatGPT is one example, while prioritizing privacy for our users, for people. So in the news, we have a lot that is happening. ChatGPT has generated a lot of this sort of dialogue. So it uses written information that's available on the internet to provide detailed responses to users' queries. In querying some of the content, we found, for example, articles, and artists found private medical record photos in a popular AI training data set. This raises questions. What is the sort of data that is used to train these models? The Canadian watchdog has raised issues because they received a complaint that alleged that the collection, use, and disclosure of personal information without consent. Italy's Garanti believes ChatGPT has a number of problems under the GDPR. For example, it can provide information about people that isn't accurate. People haven't been told that their data has been collected. So there are concerns around the basis for collection. New Zealand, of course, doesn't have some of these rights. So it's an issue that we need to have a look at. And most importantly, one of Italy's arguments is that it claims that there may be no legal basis for collecting people's personal information in the swells of data that is being used to train ChatGPT. So this leads us to our agenda for this talk. So first of all, we will talk about, we will talk about large language models, what they are, how they use data. We'll also talk about some of the data that they use. We will then look at some of the implications of large language models for privacy. We'll talk about some of the case studies, examples. We will look at privacy risks and large language models. We will look at an action plan, things that we can do immediately, as well as things that we can do in the future. And then, of course, we'll take some questions. So what are large language models and what are they used for? So just by way of introduction, so a large language model is a type of artificial intelligence. It is a deep learning algorithm that can recognize, summarize, in some cases translate, predict, and generate text and other content based on information, on knowledge it has gained from massive data sets. So as the term implies, it uses very large data sets. Large language models is one of the most successful applications of what we refer to as transformer models. So a transformer model is a type of neural network that learns the context. It learns meaning by looking at relationships among data, for example, words in a sentence. It was first described in 2017 by Google. They were driving a new wave of advances in machine learning referred to as transformer AI. So one of the very first forms of a language model applying natural language was ELIZA in 1966. So this is not a new technology. ELIZA was acting like a chatbot that gave psychological advice to the user. It could recognize keywords and then match those to a pre-programmed response. So any application that uses text, images, or video data is a candidate for a transformer model. They make self-learning possible. They allow computers to see patterns similar to how people see patterns. So this brings us to some of the more modern day examples. For example, you may have heard of Google DeepMind. We also have Google Lambda. Hugging Face is another example that was introduced by Bloom, and that is able to generate text in about 46 different languages and also code in a dozen programming languages. So closely connected to this idea of large language models is generative artificial intelligence. So this describes machine learning algorithms, a type of AI such as ChatGPT that can be used, in this case, to create or generate new content, including audio, code, images, text, simulations, video, and so on. So this brings us to a category then that we refer to as generative pre-trained transformer models. So GPTs are a type of large language model. It's trained, or in this case, pre-trained on large data sets of text that uses supervised learning, machine learning, and able to generate human-like text. We've had a bit of a timeline as far as GPTs are concerned. So in 2018, we see that one of the very earliest forms, the first version, was trained on 7,000 books. And we can follow the timeline through. This is all some of the developments through OpenAI until we get to the most recent one, which is I think it has jumped ahead. Here we go. This is a slide we should be on. Until we get to the most recent, which is GPT-3, which is trained on about 175 billion parameters. Just to put this in context, GPT-4, which is a multimodal model, which will now incorporate both text and images, has 571 times the size of GPT-3. So how are LLMs trained? And this is where we have implications for privacy. So the data that is used to train LLMs in general will include things like publicly available data. This can include personal and sensitive information. We are also looking at LLMs are able to integrate and make connections among the data in new ways, in things that maybe we know, and perhaps in unknown ways. And so therefore, it's able to generate and draw on a lot of inferences. These inferences may be true. It may reveal information that is true. It may reveal information that is inaccurate. It makes no difference. Also, it takes into account prompts to help to fine tune what it is doing. So prompts gives us a process of providing feedback into the model. So we're feeding in bits of data that it can focus on and then to help the model to train for particular applications. But remember here that GPTs remember the previous prompts. It remembers the data that is uploaded and it learns from this to fine tune and produce better responses. So we'll come back shortly to this issue around data. So we have a number of use cases. So here is what ChatGPT said it could do for us. Answer questions, provide general information, proofreading, explain complex concepts, and so on. So very quickly, we see that people are starting to use tools like this for all sorts of tasks. Simple tasks like writing poems, creating task lists. But then there are also personal tasks, writing a resume, writing an appeal to get out of a traffic ticket, asking for health advice, getting help with mental concerns, stress, anxiety management, using ChatGPT to get relationship advice. So as we go through some of these uses, we can see that the information that is being uploaded gets more and more sensitive. And then we can ask questions. Can it be used for other purposes? And then organizations are also asking, how can we use it? For example, to write emails. write reports, proofread perhaps part of a report, do a risk assessment. Can we use it for hiring tasks, evaluate employees, and advise on many other issues, for example, handling a customer complaint or request or an employee issue. Even if we do not include identifiable information such as name, models make connections, and they can uncover information that is perhaps inaccurate, but it was information that is accurate, but it was intended to be private, or it can reveal information or create information that is completely inaccurate. It presents someone in a false light. And also remember, for some of these tools, the public information plus the prompts that is uploaded, it helps the model to carry out its tasks. We can also think that some of these concerns can be exacerbated if we look at contexts such as healthcare. For example, getting medical assistance or monitoring, or creating, generating reports, processing claims, any of these. So the concerns that are raised, among others, yes, there may be concerns around IP, bias, discrimination. Those are not the concerns we're looking at in this particular talk. We're going to be focusing here on privacy. So I have mentioned already some of the issues that could come up with generating information that is accurate, but is intended to be private. And then, of course, we can have information that is completely inaccurate, but it is also generated as well. And then, of course, we have the uses. Information may have been provided for one purpose. For example, it could be information that's publicly available, but it is used for a completely different purpose. It could be prompts that were used for one purpose, but then those prompts are used to feed into the model. Those prompts may include information that has been uploaded in order to complete a task, and then that is then used for other purposes. And so we have issues around accuracy, we have issues around use. We can also have issues around confidentiality, particularly in this particular setting where it concerns people's personal information. So what are the privacy issues that these different tasks raise? And what sort of data is used, and how is this data used? So looking at ChatGPT in particular, for the training data came from 4 main sources. So one of these sources is the Common Crawl. So this was a project that basically scraped information from publicly available sites. Sorry, that just. So yes, the Common Crawl scraped information from publicly available sites. This project has been in place since around 2011. It scrapes information about every month, and this was a key source for pre-training the ChatGPT model. So you can see up in the corner that was around 60%. And then there was information that was drawn from Web Text 2, Book 1 and Book 2, and of course Wikipedia as well. There's also conversational data, so a lot of information came from things like Reddit. And then, of course, remember, there is that user data that is used as prompts. Then GPT-4, being a multimodal model, has both text and images. What is not clear is what are the sources. So that has been kept under wraps. But it does say, when we looked into it, that it collaborates with a single partner, a virtual collaborator, but that is a means for the public to be able to upload images and so on to help to train the models. And then, of course, again, it uses data as prompts. So this now takes us to looking at some of the issues. So I'll hand over now to Marcin.
Thank you. Yes, we distinguish 3 groups of these issues, and they are related to either to training data or to the user prompt data, or more general to data power of the LLM operators, or large language model operators or companies. So let's start with number 1. So training data. So as Annette mentioned, the training data includes personal information. A large part of that has just been taken from the web, and it's not fully transparent what has been taken to teach the model or the models. What is sure is that the individuals were neither asked nor even informed about that. It's well researched that the LLMs can preserve some part of the training data and present it to the output. There are papers about the ways of confirming that particular piece of data was used in training the model and how to extract the training samples from the LLM. So further, the models have propensities to so-called hallucinations. So the personal data on the output may be inaccurate or put together with some data which may together be seen as pejorative or even defamatory. So those are elements of training data which cause concern or different sort of concerns. So what are the privacy problems with it? The major one is that behavior of this model goes against one of the main principles of data privacy, which is purpose limitation. Basically, purpose limitation means that information collected for one purpose shouldn't collected from the individual for one purpose shouldn't be used for other or reused for other purposes. In other words, what is out there in the internet about us is still a personal information, and it cannot be taken and used as the LLM operators want. Other problem, or maybe even a reason for the purpose limitation, is that there is the information imparted for one purpose in one context is often not appropriate for or useful for other contexts and other purposes. And it's quite logical. People tend to reveal information in particular contexts for particular addressees. If I said something to one person, doesn't mean that I want everybody to know it and use it. So, and that's sometimes called contextual integrity, and even one of the leading definition of privacy is based on contextual integrity. So that goes, or those are the reasons that those elements of privacy or functions or maybe characteristics of privacy are reasons why we have privacy rights, that information about ourselves is protected even when it's outside of our control. And the companies, organizations, which are called in New Zealand agencies that collect and use personal information, have some sort of legal obligations imposed on them. Those regulations are different in different countries. In New Zealand, we have Privacy Act 2020, which is used also when the overseas agency is carrying on business in New Zealand. New Zealand neither has to be a place of business for that agency, nor that agency has to or needs to receive any monetary payment for the services. So the large language model, which is operating, it's accessible in New Zealand, is under New Zealand law as well. So the relevant principles of our Privacy Act are collection principles, so which describe the purpose of collection and manner of collection of private information, access principle and accuracy principles, and those do apply to training data. In the European Union, where I just gone for a short trip, and there are also rights to object and to erasure. Another thing is how to exercise those rights in relation to the model, and it's up for the discussion actually. Allegedly, there are ways to unlearn the pieces of data that have been used to train the model, but it is much more difficult for the operators to implement. Second area of risks or problems are related to prompt data. So prompt data, so that data which we use to ask model the questions. And the problems here are related to much to our behavior, because we reveal the data to the language model. So it's much about our awareness. So we do it either directly chatting with the website, with the for example, on the OpenAI website with ChatGPT, or through some sort of software providers like GPT plugins that are using the OpenAI or LLM services, providing us with those software packages, but using those interfaces through the API interface to the OpenAI API, so application programming interface, so some sort of wholesale access. That data that is used, that we use as a prompt, could be used to train the model. If so, it could potentially be revealed in others' users' output or used for other reasons, like even advertising. So it's not only a privacy problem, it is also a confidentiality problem because what we put in those prompts is not only sensitive information about us or other people. Sometimes in the organizations, people put also company secrets or information that is purely that is confidential for the organization. There were cases about American banks which banned ChatGPT at some point. There was, for example, a case of Samsung where some top secret data were leaked to ChatGPT. What are the considerations here? Quite similar to training data. They are slightly different though. So if personal data is leaked, for example, from the organization, which supposed to or is actually obligated or has to protect that information, confidential or private or personal information about, for example, users, customers, and someone in the organization decided to ask ChatGPT about doing some sort of administrative task related to the person, using that person's personal information, it's potentially a breach of privacy principles related to use and disclosure of personal information, so principles 10 and 11. This could also be notifiable data breach if that is large enough or meets the threshold for notifiable privacy data breach, which is defined in Privacy Act. From the perspective of the model, it has exactly the same considerations about data privacy obligations or rights as for training data, because they are collecting that data. So they need to fulfill or obligations related to collection, fairness, and so on. So it's possible to alleviate that problem to some extent by the identification and or anonymization of personal information. Simply speaking, we don't have to put everything into the model. There is also quite dynamic development of data leak prevention software or data loss prevention software. And about that, Annette will say a few words later when we move to what we can do about those privacy problems. The third area of concern is what we call data power. And this is also relatively straightforward. LLMs need huge processing power and huge swaths of data to run. So who is in the best position to create a successful LLM startup? Those companies who have a large swath of data already from their users and have access to huge processing power. I'm not sure it's even possible to create such a startup without the support and cooperation from one of the big tech firms, which of course leads to furthering the existing power imbalance and dependency on those big tech products. That also has a potential to shift the monopolies to the new markets that used to be competitive before. For example, should we be cautious about Google introducing an LLM or AI solutions for healthcare or other markets which used to be either competitive or run by different number of companies? AI used as a product of an LLM model may lead to monopolizing some markets which are not monopolized yet. And that dependency, actually, why it's a privacy problem, is built on personal data and its uses. So this is why we put here data power. So what is the business model? This area of concern that what we see is that LLMs are deployed in a way similar to the well-known platform model in the internet. How that works? We have LLM provider as a platform which links different groups of users. We have end users chatting directly with ChatGPT. We have some sort of wholesale users, which are just described, reusing the large language model API, but using some sort of software which links those users to the end customers. For example, it may be a plugin to your browser which uses ChatGPT API to provide you some responses or additional information to your web browsing from ChatGPT, and it can collect the data somehow while you are browsing and asking those questions. We have some sort of business users which business model is in the status of creation right now, but this is based, or will be probably based on subscription, some sort of dedicated interfaces. We have third-party products which are based on ChatGPT or with ChatGPT embedded, like Bing, like Microsoft 365. We have some sort of private deals there and potentially separate data pools for business users from corporations. What are the risks of that? Well, what we see is that sort of few-tiered model of a business model it shares the same more fast break things approach as we know from platform market in search or social media. Basically, the OpenAI started, for example, from the position of no privacy in their product at all. We see that the liability in that complicated model might be shifted down the value chain to the provider of end products and to end users, while the value will be produced by the operator of the model itself. On examples. So it would be harder for end users to impose some sort of fair conditions on terms of privacy, on transparency, on non-discrimination. There is a limited power of regulators as well, or small countries to impose meaningful regulators on big LLM providers, because it will be only a few of them in the scale of our globe. And there's a consequences, for example, of malicious or unexpected uses of LLMs could be pushed down the value chain. For example, if we have general purpose LLM model and some sort of wholesale or software providers who would be liable for AI powered or empowered manipulation, who would be liable for deep fakes, which are not done by the OpenAI itself or the LLM operator itself, but by some sort of user which uses the API of the OpenAI or other LLM provider, will be liable for loss of privacy if the third party will use the general purpose model in a harmful way. So basically, those are the three areas of problems, which are privacy problems. And to not stopping in that point, we are thinking about some sort of action plan of what we can do, or what everyone can do, or every one of us users of the models or AI-based software. Regulators, what should regulators do, and in a short and a long term, to achieve some sort of a goal, which we here tentatively described as a safe, transparent, and accessible AI services and algorithms. And I probably, and right now I think Annette has her part.
Thank you. So we've thought about what are some of the immediate steps that we can take. So something that everyone can do, what can we do now? So we feel it's very important for us to focus on the data sources to start with. So we can think about how it is that we use large language models. So some advice, be very careful about what we put into these models. So do not input personal or confidential information, especially when using public-facing GPTs like ChatGPT. But then there are also applications for internal use. And I've raised a question here on this, because some of the developments, as far as we're concerned in this technology space, so what has been released to the public is ChatGPT, which everyone is using. And of course, there have been some alarm bells raised as far as data privacy issues are concerned, particularly with putting in personal information. So one case was a doctor who wanted to get ChatGPT to write an insurance letter to an insurance company for a client. Now, one could achieve that objective, for example, by creating templates for these letters that can make that task easier for the doctor, where we do not input personal information. The other way in which we could achieve some of these tasks, and this is where the technology is going, is to actually develop bespoke applications. So applications that are used by a particular industry or by particular organizations that build on this technology. And so they build applications that are particular for that organization or for that industry. So that may resolve some of our problems that we have, for example, in the healthcare space. And Google is looking at this. How can we leverage this technology to support some of the tasks that doctors do? But then what if these applications are focused on internal use? Do we still raise questions such as do not input personal information? Well, a key question here is who should have access? So who is going to be able to query these models? At the moment, with our traditional databases or traditional interfaces, we can decide, for example, that Annette is allowed to be able to query this set of records, but if I want to look at something else, only someone else higher in the organization can query those. But once all that information becomes available through a form of GPT, we also have to make sure that we have safeguards in place so that information that is input for legitimate purposes is not accessed by persons who are not authorized to access that information, including persons who are internal to the organization. So as we said, often you can achieve the effect without using personal information. You can use existing privacy settings. So some of the most recent developments is to try to deal with some of these questions that we are raising. So OpenAI has created opt-in and opt-out options for its users. So for those who are using technologies like ChatGPT and DALL-E, there is an opt-out option. However, you have to fill a form for this, okay? If you are using the API, so there is ChatGPT API for developers, then there is an opt-in option there. In other words, there's an undertaking that that they would not use the prompts, the information that is provided by its users to train the model. So for API users, you opt in for your information to be used to train the model. For general users, such as ChatGPT users, then you have to opt out. And those opt-out options only apply from that point onwards. Then another development is looking at software filters, for example, Privacy AI. So Privacy AI has developed technologies that aim to try to find, redact, and replace personally identifiable information that's in text, audio, image, videos, and so on. And they claim quite a high level of accuracy. Now, some information is perhaps relatively easy to identify. For example, a name, an identifier like a driver's license number, social security number, passport number. But other things are based on context. And so one of the challenges here is whether or not these filters are able to, and can we rely on them to recognize what is sensitive within a particular context. So by itself, that piece of information, or that piece of data may not be problematic. But as we begin to bring them together, as we begin to merge, as we begin to find patterns and so on, that piece of information can become problematic. So there's a question about to what extent can we rely on these types of filters? So, So those techniques around filtering, data sanitization, which we've just talked about, and differential privacy, they go some way to protecting, but they are not perfect. So let's now look at some of the immediate steps that organizations, that others can take. So the regulators. Marcin.
Yes, and I'll take over for that. So immediate step for regulators are also to focus on data. The first and probably the most important part is the mindset, of regulators and regulatory policy. The AI is not equal with inevitable progress, or the way the AI is implemented or has been implemented since its beginning, and with OpenAI, for example. It's just, it requires attention and work from the regulators and work to change it to put the privacy in. And regulators need to step up and do something about it. The LLM providers, for example, are willing to make changes. We had a situation where the Italian Data Protection Authority banned ChatGPT from providing services, explaining a couple of points what they should improve, and they managed to change the policy of OpenAI in a way that everyone all globally all users have those that opt-out option for the use of prompt data as a training data. So the changes are possible, and the LLM providers are in a kind of moment of developing their services in which they will be willing to make those changes, but the regulators need to analyze the situation and not treat the artificial intelligence or large language models as given and as a progress as it should be, but think carefully how to build the privacy in, because the privacy unfortunately hasn't been built into those models. The second thing is the transparency of we need transparency of about what is used to train the data, not even about the way it works, because it's very hard, but what is used to train the data and how what is collected and how it is used. We need privacy by design and removal of personal information from source data, the identification, and so on. There, as I mentioned earlier, there are existing rules that could be enforced, could be a matter of in which the privacy commissioner or other data protection authorities could be interested in and ask questions and push the LLM providers towards the solutions that are building or including privacy in the models. We need guidance and training data for new companies, for example, and how to minimize the LLM risks for users and for providers of products based on LLMs. It's not only the LLMs, but we have a couple of tiers of infrastructure there. For the long term, it's not that easy. We believe that we should think about aligning our regulations with the global standards of privacy standards, and it means extending our privacy rights here in New Zealand, which are relatively less developed than even in Australia or you're not mentioning the Canada or GDPR. So right to object and right to erasure. We should probably align our regulation with future AI regulation. And it doesn't mean that we need to simply apply what is there, but we need to actively act towards building those regulations as we want. Probably the data power question requires actions to decentralize and demonopolize that market, because it has tendencies, and it's very probable that it will be very much concentrated. So we need to think now already how to enable organizations to build competitive models, how to make sure that there's enough data accessible for others, not only for the big tech companies. How to build an equal wholesale access to large language models, because there are practices of big tech companies that they are providing some sort of functionality only for themselves or between themselves. So we just don't need to actively think now how to not to allow those new monopolies to be created. And data, and also personal data, but data is critical, because this is the main asset of the one of the two main assets of those models. The second is computation power. Data interoperability, so the way of actually using or sharing the data between different models, building models in which the data could be interoperable between them, porting data, consumer data rights, data cooperatives, so the cooperation in which people, organization can create a common pool of data in the industry, for example, or in the country, in which could be used to train new models. And finally, last but not least, the privacy management. So enforceable privacy rights, which would allow us individuals to decide about what's happening with our data, and give us the control over we are not in a position when someone just took it and used it for training their own models. So this is maybe a wish list, but those are the steps which should or just aim, or maybe they're aiming towards those risks. So in summary, AI or LLMs are powerful, but and they need a lot of data to support innovation. We need the innovation which prioritize data privacy, and because it's in that particular area, it seems that it hasn't been built in. We need to actively work, and our regulators need actively work to build the privacy in, but the users as well need to be aware of the privacy risks and need to think before they use the models in a way which could leak personal information or confidential information. And I guess that would be it. If Annette, maybe you have something to add to that.
No, not at this time, but we do have a few questions.
Yes.
So let's have a look at some of those. Thank you very much.
Thank you. We have 7 of them. Do you feel that the improvement in the open source alternatives has an impact on the risks this represents? Annette, you, me?
So I think, and there's also another question that is perhaps related to this one, which has to do with, I think it's the 7th question about what else can we do about our data. Sorry, the opt-out question. So I haven't had a chance to look at that particular article, but there are a number of alternatives, and some of the alternatives are focused on particular tasks. What we have not had a chance to do is to perhaps look a little bit more closely at some of the policies around some of those applications. But what I was looking at is something like, say, for example, the ChatGPT API interface, which does not use, it requires an opt-in in order to use user-provided data to train the model. This might be an option for organizations. We can look at the pricing plan for it and see if that is something that, if organizations are quite serious about taking advantage of the benefits that GPTs have to offer, then perhaps they should be looking at investing in the API type interfaces. And I would hasten to add also that ChatGPT is not the only tool out there. It has become popularized because it has been released to the public to assist with training. And as Marcin mentioned, economies of scale would probably make a huge difference to the value and accuracy of that model. But it is worthwhile having a look around at other models and to see to what extent they address some of the issues that we have raised. Marcin, do you want to add to that?
No, I think you've covered it pretty well, to be honest. I don't have anything to add to that. I can probably take the second one
yes.
from Gehan. By the way, thank you for the question, Ryan. This was great. Gehan, sorry, should I reveal the people, or maybe I shouldn't? Sorry. Isn't the whole point of using algorithm to enable inferences to be drawn between things we don't think are connected, to make discoveries in new areas? How does this reconcile with purpose limitation? Yes, we would like to join the dots to use the colloquial way of saying that, and draw these inferences, but it doesn't necessarily have to be related to personal information. And I think that the whole point of privacy is in being able to reveal personal information in particular contexts. The information in one context shouldn't be used for other contexts. If I go to my lawyer, I would like to be able to get an advice and present some sort of information, and I would not want to be it to be used with someone else. The same goes with doctor. The same goes with my friend, which or who could hear my fears, for example, or problems or personal problems, and the same probably goes even with the information I present on the website to be able to communicate with myself and my, for example, academic profile. And it's about person. It's about person. It's about the fact that joining those dots in relation to particular individual can create harm, because it can reveal something which the person wouldn't like to reveal. So yes, but in privacy is slightly different, and privacy is important because we as a society we just use the information this way about ourselves, and many of our relationships we build relationships by revealing information, some particular information, just for particular person. So I guess that's where I should end it this way. Annette?
Yes, perhaps the only thing I would just reiterate with that is that because information has been revealed for one purpose, yes, we could use that for related purposes, but I think we raise big questions when that information is being used for other purposes, and I think that's where the purpose limitation applies. So we have a question from Lauren. So it says, do you think New Zealand's current privacy regulations are sufficient to address the privacy issues with this developing technology? If not, do you think it's possible to create future-proof regulations? This is a huge question. Under the GDPR, there is already a lot of movement towards addressing some of the issues that comes up with this technology. And also, I might add that this is such a rapidly moving space that, yes, we have to have principles in place that can grow with or adapt to the new technology. So perhaps one place to even start with, as far as New Zealand's current privacy regulations are concerned, to begin to even look at a simple thing like some of the rights that are provided under the GDPR, which are not available within the New Zealand privacy regime. So we do have provisions around accuracy, around error correction, around access to information, but we don't have provisions around erasure, right to be forgotten, right to object processing. So some of those would be useful for putting some guardrails around the use of personal information, whether that information is publicly available or it has been garnered through some other means. So I think there is an urgent need for us to look at this. And just to reiterate the concern, in Europe, they have already formed special working groups to actually look at this issue. So it's not only what's happening in the AI regulation space, but also to look at what is happening in this area around data uses. Mm-hmm. So, Marcin, do you want to take the next question?
Yes, I just add here that we concentrated particularly on privacy risks and the regulation related to privacy, but there is a huge area of AI regulation which has been proposed in many places, like different versions of that, and it covers much more than just privacy. But I agree with Annette that we have right now things which we can some regulations we can use. And the next one, we have seen some attempt to protect personal information in image generation context, e.g. OpenAI trying to take faces out of their training data to mitigate the generation of deepfakes, which has led to quality challenges. For example, DALL-E is generally bad at faces. What would you say to proponents of AI who might say that removing AI in training, personal information in training data, for example, privacy by design approach, would lead to decreased performance of the artificial intelligence? I would say that the first thing should be to ask those people whether they want to provide their faces to train the model, and that should be one first step, because this is not for the OpenAI to take. Second question is, if maybe that the problem won't be existing there. I don't think that broad brush approach, where let's include all faces in or exclude all faces, are the right one. Maybe it's possible to train the model on faces of those people who are willing to give them all without privacy problems. That's my take to that, to be honest. Yeah. Annette?
Okay, now I'm not adding anything to that one. Thank you. So the next question was about how did OpenAI manage an opt-out approach to prompt data when GDPR defines consent as freely given, specific, informed, and unambiguous, given by clear affirmative action? In short, the GDPR requires consent to be opt-in. And this really requires us to probably have a look at the privacy policies associated with OpenAI and around the GDPR. So what they do have is they do have provisions around legal basis for processing that is particular to certain groups, for example, UK groups, EEA, and so on, and also Switzerland, and so on. But at this point in time, we've observed that there is a lot of movement in the privacy policies as they try to address some of the issues that have come up. But I'm not sure what they have done, particularly in response to GDPR. I'll pass that to Marcin, if you've got anything on that one.
I think it's a good question, and I think a kind of academic good question, because it will be decided by the regulators. How did they manage to start with opt-out and start actually without even opt-out to prompt data? And so they have done something, and I think it's the beginning. To be honest, at least in Europe, I think it's the beginning, and that will be. There is an open probe by the German from Hessen Data Protection Authority from Hessen, who asked them a number of questions to OpenAI, including consent. There is the European Data Protection Board task force who is working on that, and there are questions from the Spanish regulator and I think French one. So it's a number of those questions, and I think that there will be a further discussion about how they did that element. So yeah.
They do cover things like, for example, how they use personal information and some of the provisions in terms of rights. So they do state very clearly, depending on your location, that you may have rights related to access, deletion, correction, updating, transferring your information elsewhere. And this includes withdrawing consent to the processing of information, specifically where we rely on consent as a legal basis for processing. And this is one of the questions that has been raised by the Italian regulators, whether or not they do have that legal basis for processing. So this is probably one of those where you almost have to watch this space, as Marcin mentioned. Okay.
The next one, we have 2 minutes, so we need to probably, yeah. Would you like to read the next one, or should I? Yeah.
Okay, the next one is about the time lag between how quickly GPTs are being adopted by users and the regulatory framework. So what can we do now besides being mindful of using personal information in the prompts? I think we've given a couple of suggestions, but thank you very much, Sylvie, for that question. Marcin, anything else you'd like to add to that one?
Probably not. We should require action, I think, I mean, we should do what we can do reasonably as users and think before using or while we are using. But we should require action from our regulators.
And I agree completely with that, especially if you end up with a technology that becomes core to how we do business, how we communicate, how we live our lives. It requires that regulators do step in and provide some protections around that. We probably only have time for one more question. How do you recommend a business balance between innovation versus privacy regulation so they can continue growing and using technology without the unintended consequences. Marcin, would like to comment?
Well, it is it thinks for me that it is a false alternative. I mean, there is a middle way between innovation and privacy regulation, and the innovation doesn't necessarily needs to be privacy invasive, and innovation could be privacy preserving and should respect people, because technology the technology should serve people. That would like to put people first, and the protection of individuals. And I believe that it's possible to innovate and to build technology which will support individuals in exercising their rights, enable them more efficient and more effective action and all the power of the artificial intelligence. We just need to start to think about it from the very beginning, when the technology is being implemented. And I think we have a good chance with artificial intelligence, because it is being created as we speak, and we have already regulators in that area, and people are more conscious. And I think the story of artificial intelligence could be much better than the story of social media.
Thank you. And just I'll just respond to just one more question, which was about whether any research is being done on indigenous data sovereignty implications of applications like ChatGPT. I'm not aware of any, but it's a really good question. And so one that we could do a little bit of work on and see what's happening in that space. Because of course, one of the big questions that has come up, it was outside the space of our presentation, were issues around bias and discrimination. So I think that is a very relevant topic as far as looking at data sovereignty. Anyway, thank you very much, everyone, for the questions. I'm sorry we are not able to go through all of them. We've provided our contact details. We are both with the Privacy Foundation of New Zealand, and we would very much value continuing this conversation offline. But thank you again.
Thank you very much. It was a pleasure. Sure.
Okay.
Shall we look at those questions somehow? Or